scaling star power, licensing, collaborations, and right of publicity. We're so happy to see you and thank you all so much for coming and joining us today. We have an incredible panel, and I will give their titles and let them speak about what they do, their experience, their day-to-day. But this is truly an esteemed panel of really distinguished practitioners in this area, and I'm really happy to be on stage with them. So just to introduce myself quickly, for those of you who don't know me, my name is Nicole Dolgon. I'm a partner at ESCA Legal. I lead our firm's commercial practice. I was the firm's first partner, so I consider myself an OG, but I am really very happy to be at the firm. We have a lot of fun together. We work very hard, and obviously you can see the culmination of all our hard work in today's event. And to my left here, I have Joey Roesler, who I adore. Joey's an entertainment attorney and an entrepreneur in every sense of the word. So please share a little bit about yourself, what you do.
Thank you, Nicole. Thank you guys for letting me be here today. My name's Joey. I operate out of my office in Beverly Hills, and I've been doing entertainment pretty much my whole career. I graduated from business and law school in Los Angeles and got into licensing at CMG Worldwide. So there we represented a lot of dead celebrities. That was very much our niche, which is an interesting market. You know, our talent is not necessarily available. You know, you've got everybody from Neil Armstrong to James Dean to Albert Einstein. And so it was a great experience turning personalities into brands. And in entertainment, you really have two buckets of income and activities. It's personal services and intellectual property. And so there, it was just the intellectual property, building out portfolios of licenses. And now we've expanded dramatically into talent. We have an affiliated talent agency that I run. And so there we just represent influencers. And so I spoke at the ABA conference in Vegas, and my slide was Albert Einstein next to a very bubblegum influencer that I represent. And, you know, the gap between them is closing with AI, which is what we're going to get into. And I'll look forward to that. Thank you.
Thank you. So to the left of Joey, we have Rebecca Kravitz. Rebecca is Associate Corporate Counsel at G3. And on a personal note, Rebecca was my 1L mentor when she was a 1L back in 2018. Sorry to date you, but look how young and youthful she is. So this is very full circle for me to be on a panel with you. So please share a little bit about what you do.
Obviously, it's great to be sitting here next to you as well, since knowing you and back in 2018. So as Nicole said, my name is Rebecca. I'm Associate Corporate Counsel at G3, or G3 Apparel Group is the full name, but we're a global fashion company. We manage 30 plus owned and licensed brands. So some of our owned brands are DKNY, Donna Karan, Karl Lagerfeld. I'm sure some of you are familiar with them. Some of our licensed brands include Nautica, Converse, Champion. There's a whole long list of them I won't bore you with, but I've been at G3 since I graduated Cardozo almost 5 years ago. So at G3 in the legal department, we call ourselves generalists. That's because we're working in a bunch of different practice areas on different matters with a bunch of different divisions. We're a really small team, small but mighty, some would say scrappy, but the work that I do primarily is focused on IP and marketing and advertising, so I can weigh in a little bit on licensing and collaborations and working with talent.
Yeah. And last but certainly not least, we have Annie Kerrick. Annie is an IP attorney at Estée Lauder companies. And I think I'm wearing Joe Malone, Le Labo, and Tom Ford today. So I'm just like a walking advertisement for you.
Yeah, thank you. My name is Annie Kerrick. I'm Trademark Counsel at the Estée Lauder companies. We have 25, 30 brands now. In my day-to-day role, I handle everyday trademark matters for 10 of our brands, including Joe Malone, Aveda, Bumble and Bumble. Those are a few of the brands I work on. I also manage our domain portfolio and our online brand protection work, as well as some of the licensing work and co-branded product agreements.
Fantastic. So as I said, an all-star lineup here. So I really liked Dwayne's introduction. I don't know if Dwayne is there. He is. You are, a trendsetter. I really like you giving kind of a State of the Union and laying the foundation from a legal perspective about what we're going to talk about today. So today we're talking about licensing, we're talking about collaborations, we're talking about right of publicity. So I want to start by laying the foundation for two of the legal theories that we're going to talk about today, or theories or, methodologies, whatever it is. One, what is licensing? Two, what is the right of publicity? So I'll punt it to you three experts. What is licensing?
I could talk about it a bit. So from a brand perspective, when you work for a fashion company, when you work for a brand, oftentimes brands are specialized in certain product categories. For G3, our brands are mostly specialized with footwear, handbags, and apparel. Obviously, there could be many more product categories that fall under a brand, but you might not have the expertise in-house to be able to build on those product categories. So a lot of times what brands will do is they work with other companies that have expertise or basically expertise or specialized knowledge in those product categories that can build those product categories for you. So let's say I work for DKNY. In-house, we make apparel, handbags, and footwear, like I said. We sell many more product categories than that. So that can include jewelry, that can include fragrances. So then we work with licensees who will basically build out those product categories for us with our brand identity in mind.
Yeah, I can add on to that too. So we see a variety of different licensing. We are licensors of the Tom Ford brand, so we own the entire brand, and we do the fragrance and the beauty in-house, and we license out the footwear or the eyewear and the fashion. We are also a licensee of the Balmain beauty brand. And then another thing we do, we co-branded product agreements. That's another type of licensing when we have it, like, for example, Bobbi Brown and Alice in Wonderland on the packaging. We work with Disney on collaborations like that. So we kind of run the gamut of all different kinds of IP licensing.
Fantastic. And it's really a mutually beneficial relationship, right? Because both parties are getting a pretty good, end of the bargain there. What would you say, this is not on my list, what would you say are some of the most important terms in a licensing arrangement? Like for me, when I counsel my clients or I'm either drafting a license agreement or reviewing one, I'm looking at what's the scope of the license. Is it exclusive? What territory is it in? How long is it in? What categories? What's the comp structure? Are those terms equally as important to you? Are those the things that you look out for as well?
Yeah, I think for us, defining what the IP is there, so what we own, what the other party owns, I think that kind of sets the parameters for a lot of these other things, like enforcement. Okay, what are you going to enforce? And then for us, on the flip side, like, what are we saying we own, and we would be really upset if you went and you did. So that is, I think, defining the scope of what both parties own. That also helps on the clearance side for us. Of course, we don't want to enter into an agreement where there's problematic IP. And if the other party can't define what their IP is, it's not really possible for us to clear it. So I think if I had to pick one most important term, it would be defining the relevant IP on both sides.
Yeah, absolutely. And to build on that idea, not only are you defining the scope of what the license is, you're not just defining what IP is being licensed, you're defining what the IP is being licensed for. So what the specific licensed products are. Because you might have a license to use a brand's IP, but that brand is probably going to limit that to a certain product category. So that's really important to define that, because sometimes it can be vague, like athletic wear, or it can go a little bit more specific to be maybe sports bras or leggings, or you could say outerwear vaguely, or you can define what outerwear is and what kind of jackets that licensee is able to develop for you. Beyond the scope of the license, what you want to make sure is that you have control over the brand identity and also quality. So you want your licensee working within your brand guidelines and parameters to make sure that the product that they're developing for you matches what your brand is and what it stands for. So that's style and then also quality. So you want to make sure that they're using the proper materials. You want to make sure you have approval rights. All of that's really important for making sure that your licensee is serving your brand. And then to go even a step further, you want to make sure your licensee is distributing in the channels that you want the products distributed in. So the license will define what the distribution channels are and where that licensee is permitted to distribute to. So this could be department stores, it can be off-price channels. So if you are a luxury brand, you might limit a licensee's ability to distribute those products into off-price channels. Oh, and then there's the financial piece. Obviously, with licenses, you have guaranteed minimum royalties. So you want to make sure that you have those included, and you might also have a minimum marketing contribution that you're getting from licensees. And then licenses are long-term agreements, but they tend to automatically renew. So you want to make clear who has the automatic renewal rights, if that makes sense, or if your licensee is subject to certain performance metrics in order for the license to renew. Because obviously, if your licensee isn't selling and you're not seeing the financial gain from your license, you might not want to continue with that license.
These are not only the most important terms, but also the most hotly negotiated. And so it's, when we talk about things like approval rights and compliance with the brand deck, a style guide, those are sometimes really difficult for prospective partners. And so they'll push back really heavily on that. And depending on how much leverage you have, you might be able to get certain pre-approval or be able to prove everything. I know that, when you're negotiating against a CAA or an IMG, they're going to come in and redline your definition of, name, image, likeness to say approved name, approved image, approved likeness, pre-production samples, everything. And so these are all important terms. And, when you're negotiating royalties too, generally the number one rule is you always want your royalty to be based on gross, because as soon as you take a royalty based on a net number, they're deducting marketing expenses, they're throwing anything and everything. It's your classic Hollywood accounting. And so you want to be really careful there. And that's all fought in the trenches on these red lines.
So that was licensing 411. So you can all go home. We're done. Mm-hmm. No, I'm just kidding. So that was, basically a really good overview of licensing, a licensing relationship, and the key terms and provisions that we as attorneys look out for and protective over for our clients. What is the right of publicity?
So in synopsis, it really evolved from the right to privacy that came about at the end of the 19th century. And you had these photographs of individuals that are appearing on goods and services in an attempt to differentiate them. A lot of people cite the Industrial Revolution as kind of the source of that. Increased competition. People said, what can I do to make my beans look different from their beans? So they started slapping people's faces on it. That was highly offensive. And you had these laws that, laid the foundation for the right of privacy. And then about 50 or 80 years later, close to the 1950s, that turned into this more commercializable, descendable, transferable right of publicity. And then there's also the postmortem right of publicity, which is very much my bread and butter, which is, for Albert Einstein, for John Wayne, Maya Angelou, they're dead, but what can be done? And right of publicity famously has no federal protection or statute. It's a patchwork of protections that come from states. Most of those states have a statutory framework. Some just have common law, which makes it extra spicy and interesting because you have absolutely no idea what's going to happen. I have a client where, secretly, we won't actually ever sue for right of publicity infringement because we fear that if we were to get a decision that's adverse to us on record, it's going to nuke their entire 7-figure licensing operation. And so a lot of strategy goes into, figuring out what rights in there. You go for more of a Lanham Act false endorsement, but it gets to be pretty nuanced. And with NIL becoming bigger and bigger, I do suspect that, with all the lobbying efforts, there will be a federal right of publicity at some point in time, but we'll see.
I agree with that. So correct me if I'm wrong, and this might be a bit of a leap, but I would imagine that each of you and your respective companies are always in a little bit of an acquisition mode. You're maybe always kind of eyes and ears open to what brands are out there, what you may be interested in acquiring, brands that you would like to collaborate with and work with. And so, two of the things that I would imagine you assess in that kind of multifactorial assessment is, one, are they scalable? And two, do they have long-term staying power, right? Because that is essentially where the credibility and the profit is in terms of finding brands that could be multi-category. So you're dipping your toes into different pools, different consumer bases, different distribution points, and also longevity. Can this withstand the test of time, the test of consumers? So what indicators are you looking for in that constant acquisition mode to assess whether a brand has staying power and to assess whether it's really scalable?
I think that's tricky, especially in the cosmetics industry these days. We see things like trends last this long.
Sure.
So while you want to keep your finger on the pulse and you want a brand that has been established and has established like a fan base and loyal users, you also don't necessarily, there's a new beauty brand popping up every day. So it's a fine line with trying to balance staying on trend and, like you said, having a worthwhile investment. So I think that is probably on the cosmetic side, the biggest thing that we're weighing. Also, if there's a gap in our portfolio, we of course have some established legacy brands like Estée Lauder. K-beauty is very hot right now, so trying to fill in some of those gaps. Yeah, I think from cosmetics, that's our point of view.
We could do a whole panel on cosmetics.
Yes.
I went to Sephora for their biannual sale today. It was very good.
I think for me and my company, it's a little bit interesting because we don't just ask, how is a brand scalable, or is it what is the scalability? It's more, is this brand scalable within the way our company works? So does it fit with the other brands that we have? Does it fit with the customers that we work with? Are we able to scale it? Do we have the potential to scale it? But if I take a step back, what I was thinking about when I was looking at this question was Rhode, because Rhode just got acquired by e.l.f. So interestingly, I'm bringing this back to cosmetics. And I was thinking about how maybe e.l.f. thought Rhode was scalable. And a few of the things that stuck out to me is that they have a clear and distinguishable brand identity. They've really built a brand identity with Rhode, and it is related to Hailey Bieber. Interestingly, she's still involved with the brand, even though it got acquired by e.l.f. I think it has a pretty loyal customer base. A lot of people love Hailey Bieber right now. Obviously, things can change. Trends can change. I think she has a very skin forward, glass skin kind of makeup or skincare focus. And that could change. That trend can absolutely change. We can go back to the 2016 makeup where everybody's putting colorful, glittery eyeshadow on their eyes. And Rhode might not be able to keep up with that trend. It might not make sense for them as a brand to switch to glittery eyeshadow. But, maybe they could adapt. e.l.f. probably sees that they're able to adapt if they're willing to acquire them. And I think at the end of the day, even if they can't adapt to makeup trends, they might be able to just keep skincare. And they've really built from one hero product to a couple great products that people love. And I think that's really important too, is that they don't have one hero product that people can be over one day or love one day and be over the next. So I think them building their brand also made them scalable to a company that was looking to make an acquisition also. So it's a few things.
I'd agree. I'd say adaptability is the number one metric for me. I think, for Albert Einstein, we're doing nootropic candy bars. For John Wayne, rustic beef tallow. For the city of Beverly Hills, we're doing a Beverly Hills smoothie. And, for whenever you're expanding a new license category, you have to ask yourself, what story do I have paramount credibility to tell? Because when you're going for a broad range of licenses, when you're trying to scale an IP, it's really easy. It's like reputation. You can build it up for years and destroy it with one bad partnership. Because ultimately what you're dealing with, regardless of whether or not it's a trademark, you're treating your IP, you're treating your brand as a source identifier for quality goods and services. And so it's easy to tear down. So you want something that's adaptable. Also, I think you need to put a lot of thought into who the principal is. Having a clean chain of title, especially as it pertains to celebrities and dead celebrities. Sometimes you have joint ownership issues. We represent Christopher Reeve, who is obviously most famous for being Superman. Well, it's easy for us to get permission for someone to use Christopher Reeve, but not obviously for Superman, right, unless they want to go cut a $250,000 check to Warner Brothers for a guarantee or in advance. Right. And so it becomes really challenging. You can actually nuke a whole brand, obviously preventing it from scaling. I have another client who died intestate 60 years ago, and his rights went from generation to generation. So now I have 82 clients for this one property. And they all have the authority to go out and create new agreements. I can't stop them. Their family can't stop them. And so you have absolutely zero continuity, and that brand will always go to whoever's willing to sign off on anything. And so that's challenging. And so if you have a clean chain of title, if you've got all of your intellectual property in one place, and also it's not prohibitive if you have multiple business owners, multiple interest holders, multiple heirs in this estate, it's easy to wrap it all up in a trust or in an LLC, and you can create that clean chain, and then you can start scaling. But if you scale and everybody's making money and then you try organizing some form of governance, it's going to blow up in your face, in my experience.
So, Joey, this question is for you. You are, as you mentioned, evaluating deals from many different perspectives for a variety of clients. And so from an agency perspective, because that is something that you also are very entrenched in, how do you price out these deals from a valuation perspective? We talked about earlier with real estate or other kind of more quote unquote tangible industries, the comps are very available and very present to you. But for personalities, deceased personalities, how do you evaluate and valuate what they bring to the table?
Well, it's a great question. And, if I weren't on camera right now, I'd say sometimes we just pull rabbits out of hats. Because, because a lot of these assets that you're dealing with, this intellectual property, it's non-fungible. And so there's not a market. We're dealing with real estate. You can look at the neighborhood price per square footage on comparable sales and properties. When you're dealing with, Salesforce, Albert Einstein software, good luck finding a comp. Right. And it's not highly distinguishable, and then to the point where it's pretty much useless. And so really what it comes down to is leverage and framing, being a zealous advocate for your clients, and then leveraging whatever comps you do have. And we're engaged often as expert witnesses. Most famously, we worked on behalf of Michael Jackson estate in the IRS litigation, where the IRS famously went after the estate who reported, the net present value of the right of publicity at time of death was $4,000. IRS thought it was closer to $500 million. And so we came in and we valued the intellectual property, valued the prospective commercial partnerships. which ended up, we said, was about $4 million. We got re-engaged with the HBO litigation 10 years later and found out we were a bit wrong. I don't usually get the chance to double check my work, but there we were off by a little bit. But it's challenging. It's challenging because we're doing licensing, it's inconsistent, it's highly variable. And so the most effective thing to do is to, pull whatever comps you can. And ultimately, when you're doing with an income-based valuation of something, you're looking at the future cash flows associated therewith, and you can run a DCF and you can come up with something defensible. But the market-based approach is whatever someone's willing to pay for it. And so my job is to, frame and position and sometimes gaslight into getting as much money as I can for my client.
Stays within this room.
Yeah.
So when you are counseling each of your clients, you have clients and the businesses that you work for, obviously your client. How do you counsel them on what you perceive to be the biggest legal or the biggest financial pitfalls? I recall when I was in-house, by way of example, I had wonderful business teams that I worked with, but, I was really kind of trying to penetrate their brains and say, remember, these 3 terms, this is what you want to look out for. This is what our position is. These are the important things. So how do you, in a licensing partnership arrangement, counsel your clients on what you perceive to be the things to look out for?
I think putting it in terms that are more tangible for them. So, for example, if you're talking about exclusivity, I say, do you want it to be exclusive? No, the other party doesn't want it. Okay, so if our biggest competitor went and launched a competing lipstick product and you give them the name of a competitor, you give them a specific product, and then so you'd be okay with this. Oh, no, we wouldn't want that. Okay, so then where would you be comfortable drawing the line? Could we do if they do a cleanser, trying to find a middle ground? But I think when you just spit legalese at them, they really do not like that. So giving concrete examples, things like indemnification, they don't know what that means. You have to explain it to them in the most simple terms and make it a concrete, explain if it actually happened, what the risk would be to them. So you might have to pay X amount of money if this happens. There will be PR implications, kind of just walking them through the worst case scenario, which of course they hate. But if you just list out all the legal issues, they're not going to listen to that. They'll say, okay, yeah, we're taking on the risk and move on. And then when it actually happens, oh, wait, we didn't know that could actually happen.
Yeah. Which is in-house CYA 101 that you want to avoid is not just putting it all in writing, but like you said, I think that's great advice. It's giving real world implications of you might be looking at this in a vacuum and just want to get the deal done, yesterday. But these are the real long-term implications of signing off on a deal or a provision like this. This is what could happen. Absolutely.
I feel very lucky. At my company, we've been doing this for so long. Our business teams are very, very, very well versed in our contract templates. So they're actually very well versed in the legalese. So it makes things a lot easier for me from a licensing perspective. They are just amazing at what they do. But I would say I agree with what both of you have said in other contexts when I'm working with other teams that are not licensing, making it so that the legalese translates into practical real world examples is when the business teams start to understand the risk and start to see that legal isn't where things go to die. It's where we assess what we're comfortable with.
Right. Legal is not where things go to die. It's where we help you live and prosper, make money. When you're working on an agreement, a partnership agreement, a licensing, a collaboration, we talk a lot today about brand enforcement. IP is king, right? And so making sure that you have enforcement mechanisms embedded within your agreements to make sure that you are safeguarding, all of you represent real legacy brands, DKNY, Estée Lauder, all of Elvis Presley, Maya Angelou, whoever, those are legacy brands that have IP as probably their most coveted, important asset. So when you're working on these agreements and you have enforcement, infringement, counterfeit, unauthorized usage in mind, what are you most attuned to as part of that process?
Well, I think from my perspective, it depends on the kind of license. For example, if it's a long-term agreement where we're the licensor, I want very strong rights. We want to be in complete control of all the enforcement. It's our trademark.
Yep.
Whereas on the flip side, if it's a short-term co-branded product, I don't want to be responsible for your enforcement, and I don't want you touching ours. So I would take a much lighter approach in the co-branded product sense than a long-term. So it really depends on the context to give the typical lawyer answer.
And that goes perfectly to my next question, unless I'm cutting somebody off on co-branded content, because something that we obviously a lot, particularly in influencer marketing and the creator economy, is real co-branded content, real co-branded ownership over IP. And so do you find that's a more complex, complicated arrangement in those influencer marketing deals where both parties are bringing significant, heavily invested IP to the table?
For our company, what we do with influencers, or what we do a lot with influencers, is that they're the ones making the content for us, and then they usually own the content, and we have a license to use it, usually on our social channels or in other marketing channels, depending on what it is. When it comes to the other co-branding that we do is actually with, or collaborations that we do, is actually with other brands. So what I've found in my practice, when you have collaboration agreements and you're working with another brand and you have two different brands who have IP and you're bringing them together into one product, when it comes to maintaining your IP rights and then also potentially owning the designs, it's usually, or the materials, the advertising materials that come from the collaboration, it's usually the brand that's doing the work that will assert ownership rights over what's getting produced. So that's, if you have a design, the brand that designs it, because usually there's one brand that's designing it, will own that design, minus the IP of the other brand. So what you're walking away with can look different depending on what the product is, but the idea is the designing company will want to own that design, but of course, the other brand will want to make sure that their IP that they want to protect is not included in that ownership. The same thing with the advertising materials. The brand that is working on the marketing will want to own that content, subject to any other rights. If you're working with a photographer, right, on advertising, you're probably subject to whatever that photographer's license is to you. So you're probably not walking away with ownership of that content either. It really, to boil it all down, it just depends on what you're doing. And I'm sure the only circumstance that we've worked with influencers in which we were able to walk away owning the content is if we worked with an influencer to show up at an event and we took that content, but that content is still subject to the name, image, likeness rights that influencer granted to us per the agreement that we entered into right. with them. So
that's a great, buy-side perspective, and my point of view from the sell side is really the same. You always go for a license. It's not uncommon to see brands, especially brands less experienced, go for work made for hire. Generally, market is whoever handles the production. As Rebecca said, will own those copyrights, which will still be encumbered by the right of publicity. But in my experience, when you do make the mistake of giving the copyrights from the influencer to the company, it creates a very attractive pitfall for them where they're going to be like, okay, well, I own this content. Now I can do whatever I want. And again, it's still encumbered by the right of publicity, which you're going back to what you asked about enforcement. I mean, it's really, as lawyers, we can appreciate that when you have a very clear right and very clear enforcement mechanisms, enforcement's really easy. It's when you have an ambiguous contract, it's when you have a novel situation that neither party contemplated before entering the agreement. That's when you get these protracted legal disputes. And then with enough mountain controversy, there are going to be litigation counsels that get involved on either side. And so I love, for sake of clarity, by way of example, for avoidance of doubt, everything you can do to ensure that there is truly a meeting of the minds and how this intellectual property, how the NIL is going to be used will reduce your likelihood of even getting into a dispute in the first place. Because if it's clear what someone has to do, you're dealing with a sophisticated party on the buy side, so they're likely going to do it.
Right. I have a rapid fire question for each of you as a little palate cleanser. This was not on the list. Favorite deal each of you have worked on? Joey, go first. You're next.
Favorite deal? I would say the Erewhon smoothie with Beverly Hills.
So
it's
yummy.
going to be pineapple. It's going to be just at the flagship store in Beverly Hills. It's going to come with a tote, and I'm very excited for that.
Oh my God, I love Erewhon. So good. Rebecca?
One of the brands we own is Wilson's Leather, and we did a collaboration with Telfar for a limited drop of apparel and handbags, all in real leather. So that was really cool to work on that.
That's fun.
Yeah.
That's really fun. Annie?
I think mine is probably Bobby Brown and Alice in Wonderland. So working with Disney was a very interesting experience.
Nice adjective.
Yes. Yeah. Interesting. Yes. I chose that carefully.
Yeah. Very cool. Very fun. Okay. So there's a lot of opportunity in this space. AI, digital, increasing visibility of different marketplaces. And so there's a lot of untapped opportunity as a result. What was an opportunity 3 years ago is, dead by this point. What may be an opportunity in 3 years, we can't even fathom as we sit at this table. So what do you see as kind of the untapped opportunities in this area that, it's going to be on the tip of our tongues this time next year?
I think without a doubt, at least in the personality space, it's going to be AI, LLMs, large language models. And, we've worked on a handful of these programs. None of them have launched yet. So it's, I think, about to be tapped, not quite tapped yet, but everybody's still organizing. And, we were approached by Masterclass. And I guess going back a little bit, a lot of legal eagles in here. You guys probably took Barbary or Themis when you were studying for the bar. And, I feel like I learned more in my Barbary course than I did in my entire 1L. And, the issue with that, you might say, well, why don't people just take Barbary instead of go to law school and spend all that money? And it doesn't scale because you're not able to have office hours. You're not able to interact with the professor. I forget the real estate professor's name, but Paula Franchese.
Oh my God,
Adorable.
I loved her so much.
Yeah, and if I could have taken her real estate class in law school, that would have been the best experience ever. I can't talk to Paula.
I took her
Oh,
wow.
she's famous.
She's a really big deal.
every day in Chanel.
Of course she did. She is iconic.
Oh, she's
and Rich
incredible.
Freer.
Yeah.
I had a crush on him.
So, circling back to that, I think.
Sorry.
So that's the issue with something like Barbary. You can't scale it effectively. And so what Masterclass sought to do was to take Albert Einstein, was take Maya Angelou, and not only have them teach a masterclass, but then you also have the AI LLM, large language model, that has been trained on all of their information they put out into the world, all of their writings, all their teachings, literally anything that the AI can digest, it will digest, and it will output incredibly realistic. And I'm not the judge of that, but the family members are the judges of that. And we've had these LLMs for Reagan, for Einstein, and it's really incredible. And so what you're going to see is online universities where Albert Einstein can not only teach you physics, but teach you physics one-on-one. And Ray Dalio can have investing sessions with you. You can go over your 401k plan.
It's crazy.
And so I think that these personality-based LLMs are no doubt going to be, the next biggest thing in licensing. And of course, you need to license those personality rights. And so we're doing a lot of that now. And this time next year, hopefully I can talk more about it because they'll be on the market.
That is so cool. I have a follow-up question to that really quickly. When you say that the family members are the judges, obviously the people that know them best, their mannerisms, the way they speak, the way they carry themselves, whatever, what does that actually look like? Are you presenting it to them and saying, hey, does this seem like the real deal?
Yeah, exactly. So Ronald Reagan Presidential Library controls the rights for Ronald Reagan. And the board consists of 8 individuals, 6 of them knew Reagan personally. And so it was an incredible experience, watching them, be initially very adverse to all things AI. Actually, I'd say top 1% aversion because I deal with AI a lot. I deal with a lot of families and estates, and they wanted nothing to do with it. And to see them totally cross that threshold and, wanting to be early adopters, demanding to be early adopters, and the programs that are now coming out in the next few months, it's been a great experience.
So cool.
Yeah,
Becca,
and
what do you
even
think?
to build on what Joey said, I think some of you may have seen that there are AI influencers that are not digital replicas of people, but they are just very literally AI, and they have been working and collaborating with brands. And there's some pushback on it because not everybody loves AI. And to work with an AI influencer when the whole idea of influencing is to recommend a product to you, but they can't actually use it, there's been some pushback there. But it'll be really interesting to see how that develops over time because these AI influencers have a lot of followers and people are really interested in what they do. And then we've seen, I think, H&M do a campaign where they took real life models and made AI replicas of them and put them in the campaign. And there was some pushback there, obviously, because there is a huge push to make sure that companies are hiring human talent, especially from SAG-AFTRA. We've seen that push, but what the whole idea behind the H&M campaign or what they had talent say is basically, it's great that I get to be everywhere at once. I can go do a shoot one place and then I'm still working with H&M because while I'm doing the shoot in one place, they're including me in their campaign also. And then we've seen a lot of celebrity talent break into the virtual gaming space, and I think we might see that continued as well.
Annie, what do you think?
Yeah, I agree. It has to be AI, to use that classic buzzword. I think The amount of content we'll be able to create will go up significantly because of AI. Like you said, AI influencers. I don't know exactly, the mechanics of it all, but AI will change how licensing works.
Totally. I'd love to take a question or two if anybody is bold enough to raise their hand. Yeah, go ahead. The question was, how can, preemptively, celebrities, personalities, public figures set themselves up for success so that when they die, their rights of publicity are not up on the battleground for everybody to figure out? And what do you think?
It's a great question, and I'm not joking when I say this. So the best thing you can do is die in the right place, and it's because right of publicity. There are a lot of different laws in different states, and the courts will attach the law of the state where the person was domiciled when they die. Domiciled being last state you were in where you intended to remain indefinitely, and so we've litigated over domicile to get a preferable state law. And we've lost. In Maryland, we famously lost. It was decided that she was actually public domain because she died and she was domiciled in New York, at least according to the court. And so there was nothing you could do for right of publicity. And what you do when you don't have a right of publicity or you want to enhance is you get a series of trademarks. But the trademark protection isn't as robust. It's also very expensive. You have to go class by class, jurisdiction by jurisdiction, and you have to actually show use. And so Beverly Hills, famously spent an obscene amount of money on their trademarks before we worked with them, and they generated less than 5% of their cost from licensing said trademarks. And so I think, you want to be domiciled in a state that does in fact have postmortem right of publicity. And then I would, obviously be very intentional about how those rights should be governed, because whenever you introduce a lot of money into the equation, especially with family, it goes very poorly. And so you want to have somebody that is going to have the right to govern, or at least like a voting mechanism such that decisions can be made expeditiously and with a level of finality such that you aren't going to be relitigating everything over and over again. And Robin Williams famously didn't want anything to be done with his right of publicity, and so that was a part of his estate planning. And going back to the IRS and Michael Jackson, what's interesting is, you will be taxed on that right of publicity, the net present value of it at the date of death. You'll be taxed regardless of whether or not you plan to even exploit it. And so, you take some celebrities that have died, they might have a fair market value of $40 million, well in excess of the, lifetime tax credit for gift and estate. And so, the family who might not have any liquid assets is now having to cut a check, mortgage houses, businesses. And so you want to be intentional about how you set it up, where you set it up, and appreciate the fact that even if you don't want to use it, you might still have to pay the IRS a pretty penny.
So is everyone else thinking, where's a good place to die?
The best place is Indiana and Tennessee. Yeah.
Cool.
Yeah.
Very interesting.
Not that I know of, but I think that the best thing to do there would be to approach it from a Lanham Act false endorsement perspective, common law trademarks, registered trademarks, false endorsement, passing off as this affiliation or sponsorship that isn't truly there. Yeah, I'd say whoever owns the principal there, they would have standing to bring a claim.
Do you ever do any work with, or what do you know about AI agents? I've been reading a lot about that.
Like agentic AI?
Yeah.
Other than them trying to take my job, I don't know a whole lot about them. Yeah, I'm certainly not an expert in it. I actually, we do some licensing work with NVIDIA, and I went to the GTC conference, and Jason Huang spoke, for a long time about OpenClaw. And he, interestingly said that every CEO should have an OpenClaw strategy. He went into
What's an OpenClaw strategy?
So OpenClaw is, for those that don't know, it's this new agentic, AI software that can jump from task to task and pretty much do whatever it wants. It's kind of a black box.
Jesus.
And it's really scary. So people will set up an independent, hardware vessel for it, and then give it information, because if you let it open on your personal computer, there are horror stories of people, texting their OpenClaw saying, hey, why did you spend $8,000 on this random Miami guy's course? And the OpenClaw came back and said, oh, well, it's going to 15x your revenue per his website. And so we highly recommend it. It's going to do a lot for us. And so, agentic AI is going to change the way that we do things on the talent agency side, because right now I pay a lot of marketing coordinators a lot of money to go through and pitch, including to you guys, to hassle you guys and hopefully not end up in your spam trying to get partnerships going. And so, when you send out mass spam, it is categorized and interpreted as such. And so you really want to have like bespoke, intentional outreach to brands. And it's hard to do that at scale, but with agentic AI, it can be trained on all of your outreach, on who your talent is on what they've done, what the recent updates are, and it can en masse send very authentic and effective outreach from what we've seen. So we're trying to do more of that, but one step at a time.
Wild.
We use AI every day, and we have a lot of different AI vendors and tools. I personally love ChatGPT for the logic. I can throw in infringement materials and templates and, substantive law that's up to date, and it can, in a matter of minutes, do what would take a clerk 8 times longer to do half as well. And so I love doing that, and also use a company called Podkey. It's actually here today. And what they do is they leverage AI to scrape the web. And so we touched on that a few times, different panels today, but they're an incredibly critical vendor to what we do, because when we've got 600 talent across the dead celebrity influencer space, and there's constantly infringements, and you get what's called a death by 1,000 cuts when you're dealing with a Martin Luther King or going back to Einstein, because you've got infringements that pop up every single day. And so to be able to very effectively take those down, create an iron dome of sorts, it's what protects that brand goodwill and allows you to attract the really big vendors, because we have done a lot of Gucci t-shirts for our different clients. And if, those same clients are getting ripped off and they have really tacky, unattractive apparel on the market, everybody and their mom is making the, Maya Angelou t-shirts and flooding the market with them. Gucci doesn't want to get into that space. And so we try our best to keep it clean, and we can do about a 50x better job this year as we're able to do it manually 3 years ago.
Yeah, our team is leveraging AI across divisions, but specifically for our legal team, we've been starting to leverage AI for, transactional roles. A majority of your work that you're doing is contract review. So to be able to leverage AI to streamline that has been really helpful. And I think we're seeing legal teams increasingly adopt that. In counterfeiting, we've seen a lot of vendors leverage AI to find counterfeits online. So those are 2 different ways that at least legal teams I see are trying to leverage AI.
I agree with those points. I had an internal client ask me if I actually read all of the contracts or if I put them through AI. I was like, no, I actually read them, but AI can be helpful, like you said, in summarizing key points. But the biggest way I use it day to day is definitely for brand protection, not only to find infringing listings, but also they can help map them and put them together so you can try to get a better scope of who this person is and how big their operation might be.
And one piece I forgot, just circling back to our discussion on acquisitions, I think that AI is going to help with the due diligence of acquisitions a lot.
Well, thank you guys so much. I know how busy you are. Thank you.